Each year, World Bank comes out with a report in which it ranks countries according to the ease of doing business. One of the factors it considers while preparing this report is whether a country has a specialized commercial court. In 2015, Parliament enacted a law which introduced the concept of commercial courts in India. However, it seems that the Commercial Courts Act was enacted to enhance India's rank in the World Bank Index rather than to bring about any meaningful change in the judicial system. The Act has rebranded some of the existing courts in India, like parts of high courts and district courts, as commercial courts, without setting up any new infrastructure or appointing any fresh judicial personnel with specialized expertise. But implementing many of its provisions is very difficult. For example, the Act says that oral evidence must be recorded on a day-to-day basis and a case must close 6 months after the first case management hearing. How is this possible to do today? There were 5,259 original civil suits pending in the Bombay High Court recently. With only about 2 or 3 judges who handle this immense caseload, how is it feasible to finish cases in 6 months? The Commercial Courts Act also fails to address many of India's outdated judicial practices. For instance, during cross-examinations in court, the judge has to dictate the answer of the witness and sometimes even the question to the stenographer in court instead of using technologies like live transcription. A lot of valuable court time in India is spent on outdated practices like marking documents. Before a document can be accepted as evidence, it has to be marked as an exhibit by the court. This takes up a lot of time. Even after a document has been marked as an exhibit, a court may eventually decide that it has no value as a piece of evidence. This practice makes sense in a jury system, where lay jurors may be influenced by legally inadmissible documents. For example, even if a juror is told to disregard an inadmissible photograph of a gruesome murder, it may still weigh on his mind while deciding the case. However, in India, where trained judges have to look at all documents in order to rule on their admissibility anyway, this practice makes little sense. Judges in the subordinate judiciary in Maharashtra are often transferred from place to place. This has substantial disadvantages. For example, let's look at the City Civil Court in Mumbai, which hears suits valued at rupees 1 crore or less. Judges of that court sometimes come from places where court proceedings are conducted entirely in Marathi. In Mumbai, they are thrown into a system in which everything is supposed to be done in English. This makes it difficult for them to grasp arguments and dictate orders with ease. Many of those judges may not have been exposed to the heavy commercial litigation which goes on in a place like Mumbai, having done mostly criminal law in the districts. What India therefore needs is meaningful changes to its judicial system.